Obviously, if the children are placed with a non-respondent parent, that would explain that. Okay. Still waiting for that connection. All right, looks like we've got a connection. Shannon, you can put us on the record now. Okay, this is the matter of the Lewis Eubanks Bradshaw minors. We have Ms. Tucker for the agency. Ms. McCluskey represents mom. Mr. Kelly represents dad. Mr. Brown is LGAL. We have parents present. Looks like the two respondent parents are both present. Looks like we've got placement also participating. And let's see, Emily Schell and Taryn Widener for the agency. So this matter was scheduled for a pretrial today, and hopefully some indication based on how our restrictions are being relaxed as to whether or not I can actually schedule an in-person trial. We moved officially to phase 2, which allows me to do in-person trials. My approach is going to be for anyone who wants to participate in person in terms of a party, certainly may. Witnesses will need to be present in person in order to afford parents an in-person trial if that's what they've requested. But I will allow as many people other than that that wish to participate by Zoom to do so. If you're not a respondent parent and not a witness, I would expect that you would be participating by Zoom. You'll be able to see and hear everything that's going on. So that's the plan. I understand we have gotten some report from Dr. Gurton that he's had a chance to review the files. A decision has not yet been formally made as to whether he's going to be called as a witness, but if he is, we need to make sure he's going to be available. I would not expect Dr. Gurton or any expert witness to have to appear in person. Even if my courtroom were wide open to the public right now, I'm going to be affording expert witnesses the opportunity to participate by Zoom. That particularly reduces the witness fees that the court has to pay, and I think it's sufficient. When we're talking about a fact witness, I understand that's more significant, that in person is more important for that in terms of judging credibility and demeanor. Those typically aren't major issues with expert witnesses. Rather, it's simply the strength of their respective opinions that comes into play. So Shannon has given me a tentative trial date of June 8th at 1:15, excuse me, for trial and disposition. And I'm, based on the conversation we had off the record, assuming Dr. Girton is going to be called as a witness, we have to ensure that he's going to be available on that date. My inclination is to go ahead and give you that trial date and then get a hold of us if it turns out he's not going to be available, and we will do an adjustment of the trial date. But this one's been pending way too long. I think we need to move forward towards a resolution as soon as possible. Anything else that anyone else wishes to address on the record today?
No, Your Honor.
No, Your Honor.
No, Your Honor.
Okay, thank you. So that trial date, combined trial and disposition, is June 8th at 1:15. So if you wish to attend in person and you're an attorney, that's easy. You can just show up. But attorneys need to let us know, let John know who you expect to participate in person, because we in turn have to notify the security desk downstairs of who indeed has permission to enter the building. And then what happens is they check in and then they wait until we're ready for that case. So we don't have multiple parties in the courtroom at the same time while we got cases stacked up. Shannon, is there anything else scheduled on June 8th in the afternoon?
No.
All right, so in all likelihood, they'd be able to come right in. So that's June 8th at 1:15. So again, make sure you let us know which witnesses you're expecting to attend in person, and obviously which parents are going to attend in person, because the parents absolutely have a right to do that.
Your Honor, I know my client will be, and I'm sure Ms. McCluskey's client will be, but on the off chance that any of the witnesses have an issue coming into court, do you want us to address that with you, or just simply email you and copy all the attorneys giving you that notification? They'll just testify via Zoom.
Well, and yeah, let me ask, I'm assuming that the parents are going to insist that, with the exception of experts, that all of the petitioners' witnesses need to be in person. But Ms. Tucker, what's your feeling as to respondent witnesses? Would you also insist that they be in person? Are you okay with them testifying by Zoom?
Whatever their personal preference is, I don't mind either way.
Okay.
Like the court indicated, I would have my witnesses in person and therefore I would be in person. But in terms of the other witnesses the attorneys are going to call, it doesn't matter to me, whatever their personal preference is.
So for any witnesses for the respondents, if they're uncomfortable coming in person, we'll allow them to testify by Zoom, but it has to be visual and audio, obviously. I don't want any witnesses testifying over the telephone or with a blank screen. So they obviously need to have good internet if they're going to do this. Okay.
Thank you.
I think that covers it. We'll see you all back here on June 8th, barring witness availability. If you become aware of witness unavailability, please let Shannon know as soon as possible so that we can let everyone else know.
Okay.
Okay, thank you. Okay, and then we have the Zischke matter. Ms. McCluskey is the LGAL. Let's see, here's my list of cast of character. Well, I misplaced it. Oh, here we go. So we got Ms. Plum. Let me get her in. let's see, Mr. Weed, looking for your client. Were you
I
expecting?
don't believe he's joining. I said it wasn't necessary. Is that, should I
Okay.
not? Yeah,
All right, he's not logged in, so that's fine.
okay.
In our off-the-record conversation, I had indicated the possibility, the very likely possibility that we may be able to start doing jury trials as early as July, given the recent relaxation of both mask and social distance standards for fully immunized people. I don't know what currently, even though the standard's been relaxed statewide, it hasn't been relaxed in the courthouse. The rules we are operating under as directed by the Supreme Court is because of the difficulty of verifying immunization status, that they're going to continue at least for the immediate future, requiring the wearing of masks within the courthouse. But I'm anticipating that come July, when the mask mandate is being rumored to wholly disappear, that from that point forward, it will probably disappear for the courthouse as well. So with that optimistic view of the future, I'm going to go ahead and schedule a jury trial in this matter. Shannon had originally given me the 20th, but I learned from Mr. Weed that he's unavailable. So at least for now, we'll identify that as July 27th. And in the off-the-record conversation, Mr. Weed indicated that he may be speaking with his client about the possibility of withdrawing his jury demand in order to get an earlier trial date. And we're certainly open to that. I can start doing in-person trials. Like I said, I can do them now. So Mr. Weed, if you could let us know as soon as your client makes that call, and we'll be happy to advance it on the docket. But until we hear otherwise, we're going to shoot for July 27th at 1 p.m.
Great, thank you, Your Honor.
I meant to mention this earlier. With respect to jury instructions, it's been a long time since I've had a neglect jury trial, years. But what I do remember about them is I really didn't care for the standard jury instructions in a lot of respects. It looks to me like they might be patterned off criminal jury instructions. I'm not really sure. But I would encourage Mr. Weed, you and Ms. Tucker to get together and consult about those jury instructions. And see if you can reach some kind of an agreement. For example, the standard instruction says read the petition. I don't think, depending on whether there's a long CPS history, that you want me reading the petition to the jury, because usually there's a lot of stuff in there that that's historical, that's not necessary for the immediate circumstances that brought the child or children into court. I sure wouldn't want my client's sordid past paraded in front of a jury unless it's something that's going to actually be addressed at trial. So, I mean, that's one example, but take a good hard look at them. I think we can probably do a better job of writing those than what the standard instructions say. Okay, anything else I need to deal with on the Zischke matter?
No, Your Honor.
Your Honor, thank you.
Okay,
Your Honor.
thank you, everyone.
Thank you.
All right, and that brings us to some post terms.
Your Honor, could we just get the date and time for Highland Allard?
Oh, yes, yeah, thank you.
Yep.
Shannon, they want time next week to address parenting time. Because of the last minute changes, we're not able to have the parents participate, and they need to participate for
Okay,
that.
hang on 1 second. Let me make a note so I don't forget it. Allard Highland to address parenting time. Okay. So next week is the 25th. So let's do it 25th at 9:15.
9:15 next Tuesday.
And Miss Carol, I notified the judge that you do not need to writ or have my client there, as it's only addressing parenting time and he is in the DOC.
Well, that's good because I don't do that anyways anymore. The prosecutor's office does it.
Okay,
Yes.
well, no one has to do that.
I got it. Thank you. Your Honor, I hate to be a pain on this case because I know we're going to address parenting time for next week. In emailing with the agency between our in-chambers meeting and going on the record just now, they sent me your latest court order regarding parenting time. And I would just like some direction before next week so that we're not violating that order in any way.
Yeah, hold on a minute. Would you go grab that file? It's on the end of the counter. Allard Patrick Highland. It's a thick one. Unless you put it away already.
I put it right on your counter.
Okay, that's it. Thank you. All right, so let me get the most recent order out.
I'm looking at one dated April 13th. It's handwritten by Your Honor.
Yeah, I'm reading it.
Okay.
I gave discretion to conduct in-person parenting time between the mother and Haley and Dustin. And I gave discretion to terminate any visit if it is upsetting to either child.
So I just want to clarify, to me, that sounds like you gave discretion to conduct in person. And then if in person doesn't go well, we can terminate it, but it doesn't specifically say that we can go back to suspension or, to not holding in-person parenting time. So I just want to clarify with the court on that.
Discretion to conduct in-person parenting time includes discretion not to conduct in-person parenting time.
Okay. And I just wanted to make sure because the following clause kind of threw me off. So we can address that more next week, obviously. I just wanted clarification on that.
Okay.
Thank you.
You're welcome. Okay, now we're ready for,
Have that file too, please.
oh, sorry. This is the one I took in my bag.
I don't think so, but it is possible.
It was of the same
It is
F.
possible.
Okay, Jordan Harbert, let me see. I've got Joy Jennings.
Your Honor, I got notice that it's actually going to be Patricia McGuire covering for Joy Jennings.
Okay, I see her. And I see Jordan is here. We'll let him in.
Stacia Milligan is here too.
Oh, okay, let me get her in. Okay, this is a matter of Jordan Harbert. I see Jordan is present. Good morning, Jordan. Uh,
Good morning, Your Honor.
Mr. Brown is special counsel, special advocate for Jordan. Mr. Kelly is LGAL. And also present are Patricia McGuire and Stacia Milligan. So, Mr. Kelly, how's Jordan doing?
Your Honor, I'd spoken with Jordan yesterday. He is doing better than what the court report has indicated. He did understand why he went from a level 3 to a level 1. As the court can see by his grades, he's doing well in school. Also, the report references that he indicated to me that his therapist will be keeping the letters from his mom until he can go over them with her at a later time when he feels he's more emotionally and in a stable place. Otherwise, I don't have any concerns, Your Honor, at this point in time. I would I would request, though the report, it indicates there's more recommendations. One of the reports, I can't remember which one, said there was more recommendations from CTAC. Unless I missed those, did those get spelled out somewhere else as to what those recommendations were going to be? Does anyone know?
Ms. Milligan or Ms. McGuire, do you have any further information about CTAC recommendations?
I don't have anything further than what's in the court report, Your Honor.
I believe it's just in reference to the one CTAC report. It is not anything new.
Nothing further, Judge.
And Ms. McGuire or Ms. Milligan, do either of you have anything to add?
No,
Do
Your
not,
Honor.
Your Honor.
Jordan, is there anything you'd like to say?
No, Your Honor.
Mr. Brown?
I think we're ready for some extended overnights with the grandparents, pre-adoptive placement. I don't think there's any reason why we can't do that on a limited basis. I think the only reason before is because of COVID restrictions. And if there's a concern at the facility, I would ask that if everyone is vaccinated, Jordan's 16 years old, he can get a vaccine. And if everyone is, then there's no impediment to overnights with the grandparents.
So currently, there's discretion for supervised I'm sorry, that's with the mother. I don't frankly have a problem with Jordan having overnights with his grandparents, provided placement in the agency are in agreement that he's ready for that. I'm not in a position to order it to happen, but I'm not in a position to order it not to happen. Yes. Yeah, you may speak. Tell me your name first, please.
Casey Nadler. I'm Jordan's therapist at Havenwick.
Go ahead.
I just wanted to let the court be aware we have not vaccinated any of the residents yet. The health department has not come to do that. Jordan's grandparents are not vaccinated either. We do have plans to vaccinate, and when we do, we will look at the possibility of passes for Jordan. But at this point, nobody has been vaccinated that is involved in this discussion.
And my references were if the grandparents were vaccinated. So if they're not, then I see your concern.
Thank you.
Yeah, and again, I have no problem with the visits provided everyone's on board, that necessary safety precautions exist, and you think that Jordan's ready for it.
Thank you, Your Honor.
So, I'll leave that decision in your hands. Okay, we'll set our next review hearing for November 2nd at 8:45.
Was that okay to set it out 6 months, Judge?
I think so. We're not in a situation here where I need to look at this case every 3 months. I think moving to 6 months, which is all that the law requires, is adequate. And if there's ever a reason to bring it in front of me sooner than that, anybody can ask for an early hearing. So I think that's a good idea to move to 6 months reviews. So that hearing will be November 2nd at 8:45. Thank you, everyone. Have a
Thank
good
you.
day, Jordan.
Thank you.
Have a good day, Your Honor.
And next up is the Hillsdale case, Jack and Nathaniel Shealy. Let me get those folks in.
I didn't see any prelims. I'm going to log off. That's my last case if there's nothing more.
Yeah, the only thing we have after this is Cavender adjudication at 1 o'clock.
Thank you.
Thank you, everyone. As soon as we have audio connections with everyone, we will proceed.
And they claim they sent me the report, but I have not received it.
One more connection we're waiting on, and that's for Jack. So while we're waiting for that, can you enlighten me as to who is on G. Scott's iPad?
Yes, Your Honor. My name is Scott Smith. I'm the attorney for Robert Shealy.
Oh, okay. Let me fix that on my screen. And it looks like Jack's internet connection is a little slow. I can possibly dial him in if we're going to continue to struggle here getting a connection. Oh, here we go. Okay. So it looks like we've got everyone here. Let's first of all have the attorneys enter their appearances.
This is Roderick Dunham on behalf of Danielle Shealy.
Jamie Wisniewski on behalf of the petitioner.
Scott Smith on behalf of Robert Bostatter.
So where's Jack's attorney?
I assume that's Roy Brandis.
He has dialed in before, but he's not here right now. Let me see if we can figure out, is there somebody that can get him a quick message and tell him to dial in?
He called my office just a little bit ago, so I know he was trying to connect. So let me check and see if she can reach him.
Thank you.
All right, she's going to call his office really quick. Like I said, I just got a message from her that he had just called. So, and hopefully he'll be on in just a minute.
Thank you.
Your Honor, this is Maya Kavanaugh with Hillsdale DHS. I apologize. There was some errors with email in getting the report out to you and Miss Carroll. And I see that my supervisor has just emailed you the court packet.
Oh, let me, Shannon, can you print out that report?
I don't have it.
She said it was just emailed just now.
My office also forwarded it to Miss Carroll this morning when we found out she didn't have it.
Right, I know it, but I haven't received it. They said they sent it 15 minutes ago. I've got nothing.
It still hasn't come through. I wonder if it's getting caught by our spam filter. Do you know how to check that, Shannon?
It's not, because I already checked it, so.
Your Honor, my supervisor just emailed it to your email also.
Oh, all right. Well, good. Let me get mine open and see if I've got it.
Can you verify that they have the correct email address for me as well?
Yeah, give me a second here. I definitely do not have it in my inbox either. What email address are you using?
For you, Your Honor, it went to rlaflamme@mijackson.org.
That's the correct address.
And for Miss Carroll, it went to scarroll@mijackson.org.
Yep, that's right.
Okay, well, those are both correct. Let me check our firewall. Take me a minute to find that and log on.
Let me just log off and log back on and see if maybe that might be something.
Oh, it's definitely not in our quarantine either. I wonder if there's a problem at your end with your server.
That could be a possibility. I don't know why that would affect Miss Wisniewski forwarding it, though.
I agree. You're on different servers.
Correct.
Yeah, I do not have anything in my inbox. Well, that's not very helpful. Okay, let me see if Mr. Brandeis has shown up.
Case
I
says,
do not.
he says he is. So it should be maybe in the waiting room, I would hope.
I'm looking in the waiting room. He must be dialed into the wrong courtroom because he's not in my waiting room. Do you have his phone number? I can just get him on by phone. Let's do that instead of keeping everybody waiting.
Sure. Let me see. Rod, do you happen to know his number offhand? Because I always mix your number and his number up.
His office number is 517-437-3307. That's the number he calls in on, so it's, I guess, busy.
And that would explain. Yeah, he's in. If he's in somebody's waiting room, it's not mine. He must have plugged the number in wrong or something, but he's definitely not here.
I love technology so much.
Let me try again.
Roy Brandis Law Office.
Good morning. This is Judge LaFlamme. I think Mr. Brandeis is trying to log into my courtroom, but he's not there, and we'd like to.
Hold on and let me get him.
Wonderful.
Hello?
Mr. Brandeis, good morning. This is Judge LaFlamme.
Yes, can you give me the proper meeting number, Judge? I've been given 3 so far, and I've been on hold since 8:40.
Let's see. Shannon, do you have that readily available? My meeting ID?
929993795.
So it's 929.
Okay.
9937935.
I'll be right with you, Judge.
You can do it by phone if you like. Well, apparently he didn't hear that.
Shannon, I just tried to resend it to you again, so hopefully this time you'll get it.
I've got it.
Okay, I was like, I tried again, I swear.
It came through this time. Could you print it out, please?
What I'm doing right now.
Thank you, Shannon.
Welcome.
And here we go. Mr. Brandeis.
I'm here, Your Honor.
Wonderful. Okay. While we were trying to track you down, we were also trying to figure out why neither I nor my clerk had a court report. Apparently it got sent multiple times, but never got through to either one of us until just a moment ago. She's printing one off for me, so as soon as I have that and have a quick chance to look at the recommendations, we will go forward. It would appear that Jack is struggling in school. In terms of his grades, Nate's recovering from a broken hand. Otherwise appears to be doing well. And with the exception of his grades, is getting along okay with his grandmother. Recommendations are simply that they remain temporary wards and that the permanency goal remain guardianship. Council, do you have any position on the recommendations or any comments on the report?
Yes, Your Honor. Roy Brand is speaking, and I represent both children. I know this is the neglect case. Both children have been on the delinquency docket. With regard to Nathaniel, he was, up until very recent, placed at Maurice Spear campus. There was a bit of a scary moment here, probably a couple months ago now. The Hillsdale County Family Court was going to release him from jurisdiction, turned over to the Department of Health and Human Services, but there was no place for him to go. So literally, I was concerned they were just going to open the gate at Maurice Spear and he's going to walk out on his own. Fortunately, a placement was found, and it's turned out to be really a very good placement for Nathaniel. Frankly, he's thriving, doing well with his current placement and getting along with the foster family, and they appreciate him. So maybe this was a blessing. With regard to Jack, as you are aware, Your Honor, you have been assigned the delinquency case. We are still trying to schedule a trial date. We've had difficulty due to COVID in trying to get a courtroom. You have graciously offered to come down to Hillsdale County to preside over this trial. However, the courthouse isn't open. We had it scheduled for the May 21st. That had to be adjourned. It was again scheduled for May 28th. Obviously, that's not going to take place since we're still in phase one. I do not know if there has been a new trial date set. Well, aside from that, and you did mention Jack struggles with his academics, and frankly, he has historically. He is being given some extra help, and I think he is very, very steady and happy in being placed with his grandmother, and I think his grandmother gives him appropriate support. I have kept in contact with Jack. He's understandably anxious about this trial coming up, whenever it is, but I think that placement for both boys at this time is appropriate. That's all I have, Your Honor. Thank you.
In the last I heard from my secretary who handles delinquency matters is she's still waiting for Hillsdale to give us a date when the courtroom will be available. Anyone know, they went back to phase one. Are they still there?
I believe we're still in phase one because there was an uptick. I'm hoping that we'll move back up because of some declining cases, but I think the new COVID variant hit the county and it made our cases skyrocket for a little while.
Mr. Dunham, any comments on the report of the recommendations?
There's really nothing for me to say, Your Honor. My client I've not spoken to in maybe a year. She's been out of the picture, Mom has, for a long time. She was never happy with the system anyway, but she's pretty well out of it. So there's really nothing to say on her behalf. I hope that this guardianship goes through in the near future. Thank you.
Is this going to be an EPIC guardianship or a subsidized juvenile guardianship?
I don't know what. I don't know.
Sorry, Rod. I was to say, I suspect on the boys' ages, it will likely be a JG.
And I know one of the issues with juvenile guardianships is licensure. This current placement that Nathaniel is in as a non-relative, were they already licensed before he was placed there, I'm assuming?
Yes, it's a licensed foster home.
And they've been licensed for a substantial period of time?
Ms. Kavanaugh, do you know the answer to that?
Yes, this home has been licensed for several years.
All right, good. I know when we get a new licensure, we have to wait 6 months before they'll even consider a subsidy request. When do you anticipate requesting a guardianship subsidy?
Well, Your Honor, it's kind of a unique situation for Nate. In previous conversations with Nate, we have talked a lot about what a guardianship placement would look like for him and what he thought a guardianship placement would look like. And his guardianship placement, when I asked him about his current placement, he said he doesn't see that as his long-term guardianship placement. He has stated previously that he has wanted to stay in the Coldwater School District. He's doing very well in that school district. He has a job, a part-time job in Coldwater. But as of recently, I was provided some information that possibly there was a letter submitted to the court by grandma requesting that the court order guardianship for both of the boys. That recently have a phone conversation with Nate asking about, are you interested in guardianship or placement with grandma, which Nate said at that point in time, which was just last Friday, yes. Nate's situation is a little bit different from Jack's. So Jack has just recently turned 17. I have We've been told through our licensing that licensing the home of Terry and Vernon Krebs was probably not going to be able to happen or a possibility. I'm in a conference with my supervisor and hopefully a licensing supervisor later this week to confirm that. But if licensure was possible with Miss Krebs, it would take at least 6 months to get her license. And then Jack would need to be placed for 6 months, which then we would probably be at the or past the point where he would be turning 18.
Thank you. I just let someone in with a telephone prefix of 616. What is your name?
Nate.
Oh, okay. Well, welcome. If you were waiting a long time, I apologize. I just happened to notice that the phone number had dialed in. Okay, well, I appreciate all of the updates. Glad we finally did get a report. I think the recommendations are appropriate. I will make the necessary findings in my order, and we will set our next review hearing for August 17th at 8:45. Thank you, everyone.
Your Honor, I won't be
Yes.
here that week, but I'm not sure you need me. Mom never appears, so it doesn't matter. I'm on vacation that week. I've had it set off for a year.
I'm willing to waive your appearance, Mr. Dunham.
Thank you.
August 17th at 8:45. Thank you, everyone.
Thank you, Your Honor.
Nate, was there anything you wanted to say?
Sorry, what?
I just asked if there was anything that you wanted to say.
I just want to be placed with family.
That was, while you were in the waiting room, that was definitely communicated with the court, and the agency is looking into it. Okay, thank you, everyone. That concludes our hearing. Have a good day.
Your Honor,
Yes.
excuse me. This is Scott Smith. Before we break, as with Mr. Dunham, I'm too on vacation on the 17th. My client has even a longer history of non-appearance than Mr. Dunham's. My client has never participated in these proceedings, has been in the state of Ohio, was finally tracked down in June of 2019 and had no interest in participating. So I too would ask to be excused from the August 17th hearing, Your Honor.
Very well. I will waive your appearance as well under the circumstances.
Thank you, Your Honor.
Thank you, everyone. Have a good day.